Thank you. Well, I'm excited to speak about substantive human-centric IP standards in the age of AI. I was trying to remember who came up with that title. It's hopefully not me. I mean, either generative AI made it or I didn't get back to them with the title in time and they picked something very descriptive. But, mainly I view my role in life as helping Alina and folks like her reuse her PhD dissertation, which I thought she'd be more appreciative for, but apparently not. Anyway, there's a whole lot of fun stuff to talk about in 20 minutes, but here's one I recently did on Google Gemini. I said make a creative image and it made that. And, think what you will about the image. All sorts of very interesting philosophical, factual, technical, computer science sorts of issues underlying all of this. But for my purposes, one of the things that I think is interesting is that if you were to say what traditionally makes a human being an author, it is not me saying to someone, generate a creative image. It is someone coming up with this, right? And so that traditionally human creative act can be entirely automated and in a way trivially done on my cell phone. Now, you can have all sorts of, there's a big spectrum between, fully automating the traditionally creative act, which I've done here, to having PowerPoint, which now does an awful lot of formatting my slides for me, but I'd say is augmenting me at best, and all sorts of stuff in between. At the end of the last session, we talked about where do you draw the line on that, which is an impossible task, although I have a test for it, and it's a terrible test, but all the more reason we shouldn't have a line drawing exercise. And of course, people feel very differently about when AI does things rather than when people do things, for social, religious, philosophical sorts of reasons that maybe aren't tied to why we have copyright in the first place. People feel a little bit less of that when you have AI doing inventive things. This is a graph showing that there's a lot of AI-generated drugs these days, although that is a very complicated concept, what an AI-generated drug is. But whatever it may be, there's a lot more of it than it was before. And really, all the big drug companies are now using generative AI in drug discovery and repurposing, a little or a lot, and in very complicated sorts of ways. But, my favorite substantive AI standard is subsistence and inventorship and authorship for reasons to do with me. So I'll start by talking about that. But before we had a case to kind of ground all this in a fun case, we just had a lot of conjecture about, what would happen if you used an AI to make something? And I don't know. Who knows? So let's find out. So I work with a computer scientist, Dr. Stephen Thaler, who has some innovative AI systems, which we could talk about and are complicated. But basically, he had an AI make a couple of inventions, one of which was, using the machine architecture that combined basic into complex concepts, one of which was a beverage container based on fractal geometry, would make it easier to grip. At some point, this became interesting enough that I had Surrey print one, and sure enough, it is surprisingly easy to grip. Very difficult to drink out of, impossible to clean, and only after I drank from it quite a bit did the person who printed this said these are made out of toxic chemicals, don't drink. But I seem fine. Anyway, we filed a patent on it. We filed at the UK IPO because they did a substantive exam without looking at inventorship. Then we said, oh, by the way, this was made by an AI system, right? Not that the AI would have a right, it's a machine. The person who owns the AI would have the right. And we broadly argued this is how property works, that if you own a machine that makes property, you own that property. That applies in the case of intangibles with, things like cryptocurrency or interest on principal or goodwill in a business. It applies physically. It's something we're very familiar with as the fruit of the tree doctrine. Anyway, so it went out to a whole bunch of places and we saw what happened. And in 2021, a patent was issued in South Africa with the AI listed as the inventor and the AI's owner as the owner of the patent. South Africa doesn't do substantive exam, but they do formalities exam. And where it was rejected, it was on a formalities basis. The very enlightened Justice Beach in the Federal Court of Australia a week later held that under Australian patent law, an AI could be an inventor and an AI-generated invention was protectable and the owner of the AI had the clearest claim of entitlement. What happened after that was less exciting. The US rejected it. I want to come back to that. Not every judge in the UK felt that we should get our patent on this, sadly. We had a split Court of Appeal decision. The UK Supreme Court ruled against it. It is actually, strangely enough, going back to the High Court after this. We could talk a bit about that too. But last year, we did prevail at the highest German civil court, whose name I can't pronounce, resolving a circuit split. That's actually true. I really don't want to try and say that. Resolving a circuit split between appellate courts. The German civil court said, well, you have to have a human inventor for an invention, but it's not like the US or the UK. You don't have to conceive of or devise an invention. You just have to cause an invention to be made. So on the facts of our case, we had someone who used the AI to make an invention, although we argue he didn't traditionally invent it in the meaning of being the deviser of the invention. And so you have this kind of interesting thing where the USPTO, in light of the case, has said, all right, well, you have to have done a traditional inventive act. So if you use generative AI to make an invention, here's a bunch of stuff you can patent and here's a bunch of stuff you can't. Like you can't say optimize an industrial component. You can't say generate a bunch of dependent claims, which people are doing now. A lot of AI being used to draft patents. But if you have enough intellectual control over the idea, yes, you can still patent it. And we don't have case law on this yet. It's going back up to the Legal Board of Appeal in Europe. And Brazil, some of my slides are a bit cut off here, so there was content here. But Brazil has just introduced a bill to explicitly protect AI-generated inventions. At one point, the AI was going to own the patent. Someone realized that was kind of confused. They fixed that. And now it's going to have a shorter term of protection. But it's not just subsistence standards. All sorts of interesting standards are based on human behavior, and human behavior that is increasingly done by AI systems or using AI systems, right? One of which is the standard of the person having reasonable skill in the art, which, for those of you who don't do patents, is kind of the benchmark for what makes something patentable. Would a skilled person find something obvious? This is sort of your average pharmaceutical researcher. And back in the day when they were making monoclonal antibodies and all the best-selling biological drugs are monoclonal antibodies, it took a lot of trial and error manual process. And now you use AI systems to say, generate millions of variations on an antibody and test all of their binding affinities against these known targets. And AI is used increasingly in this. And it's not, too much of a leap to appreciate that this sort of use of AI is making skilled people more knowledgeable and more sophisticated by being easily able to do things they couldn't have done before with an awful lot of manual effort, right? And this isn't just kind of conjecture. This is actually from a few years ago that DeepMind here was saying, we're using AI to fundamentally solve scientific problems. A complicated statement, but the principle is there, right? Other ways that the USPTO is looking at this right now is in the context of prior art. So they're wondering, well, if you have AI make prior art, does that really count as prior art? And people have strong and different opinions about this. My opinion is, well, yes, it should be prior art because we're looking for advances over prior art, not caring about how it comes about, but other people feel differently about that. Right, on the copyright side of things, Alina was saying earlier, why are we still talking about this? Because before it was just sort of academically fun for me to keep saying the same thing over and over again, and it got me invited places. But now people actually commercially care about this because 35 years after the CDPA was amended to deal with computer-generated works, now finally they actually are useful. The US has had a policy since 73 of not allowing protection on this, and they based it on the sort of dicta we were talking about earlier that, human beings are authors, creative things come from the mind. If you're taking a picture of Oscar Wilde, someone's own intellectual creation went into making this sort of thing. And surely that is true, but of course, back in the 19th century, the only thing that really could have been an author was a human being. And now we have machines that are at least functionally generating original and creative output. Now, if you want to think about how much neural networks mimic human neural networks, as someone who in medical school did spend a bit of time tinkering with people's brains, not living ones, largely. Well, maybe with drugs. Anyway, There are computer scientists who say really there's really nothing different at all fundamentally from a biochemical machine in the form of a human being and a neural network, except layers of sophistication and nuance, right? This is an unknowable philosophical question. To me, it's an irrelevant one because we're not asking what should copyright philosophically think about the nature of mind. We're thinking that we have a social problem. We don't have enough creativity without copyright law. And what rules are going to best get us the output we want? So if the purpose of copyright and patent law is we want to encourage people to make inventive things and make creative things, it really shouldn't matter if they're using AI in that, including if they're just saying to AI, make a better drug, make a creative image, if you're getting a better output, even without a human in the loop. Really hasn't been a case on the copyright policy for 35 years. There were these fun monkey selfie cases which got tossed out, but tossed out not because a monkey couldn't take a photograph, but tossed out because monkeys can't bring lawsuits in the United States. And speaking of creativity and innovation, monkeys and all sorts of animals are creative and make art, and there's markets for them. They're not people. They're like people somewhat, kind of. Now we get to the modern phase and we have Space Opera by Jason Allen, who submitted this piece to a Colorado State Art Fair and won, and then said, oh, by the way, I used Midjourney to make this. This was a couple of years ago, and everyone got very upset, including the Copyright Office, which invalidated his registration. And he said, well, I used Midjourney, which is a generative AI system, but really I was the author of this. I mean, a lot of thought and iteration and prompting, and the Copyright Office said, no, use generative AI. Good luck. There is a line drawing exercise here. I think the only way you could do it is to basically say, if the AI was a human being, who would be an author here? The AI, the human person, would it be a joint work? What rules do we want around that? There is a lot of jurisprudence on this. If I commission a piece of art like this, what I have to do to be an author as a commissioner. This is my piece of artwork, not that I had anything to do with making it, but it was made a while ago, before generative AI was so cool. It was made in 2012 or 2013, again, by one of Dr. Thaler's machines. And I applied for copyright registration for this in the US, where some of you have been kind enough to note recently that the Court of Appeals rejected our case. But there, very different copyright rules, or a little bit different copyright rules than you have in the US. In patents, inventors are defined as individuals. In the US, authors are not defined as anything. Not only that, but for more than a century, authors have been corporations and other non-legal persons in the United States with no requirement to disclose any contribution by a natural person to a work. So they do not have a human-centric authorship standard. They also have a very explicit line of jurisprudence from the US Supreme Court that copyright exists to benefit the American public through the generation and dissemination of creative works, not to directly benefit authors. So we argued that either the AI was the factual author because it made the thing and the ownership rights would go to the AI's owner, or that it was made under the work for hire doctrine, which is what allows companies to be inventors in the US, or that, in this day and age, we need an expanded understanding of what it means to be an author. An author may just now be someone who says, make a creative image, right? That wouldn't have worked before, but we didn't previously have a technology that could do that, right? And AI is a tool in some sense, but, different than a paintbrush. So that happened. We are planning to appeal it. But I'll just kind of end on this thought to leave some fun time to talk about things. There's this concept in computer science of an artificial general intelligence, which is an AI that could do really any intellectual thing a person could do. This is an old graph from a Kurzweil book. I think The Singularity is Near, which was 2005. And his timing has been pretty good on this. But whereas 5 years ago, computer scientists were like, well, we're not sure we're going to get AGI. And if we do, it's probably going to be at least 20 years. An awful lot of computer scientists now think we're going to have AGI within the next 5 years, which is going to be dramatically disruptive to this sort of thing, and also make distinguishing between human and AI contributions often impossible, or at least impractical. So I'll stop there and open it up for questions.